Good evening, everyone. Yat al-ina shik'e ado shidin'e. She'eya Tatiana Benali, Yanishya, Tchotona Sha, Nonis Ejitachini Nishlin, Nashashidin'e, Bashichin, Kintlachini Dashiche, Ado Bidani Dashinele, Akut Ego Dines Sanishle. Hello, my name is Tatiana Benali. I am from Sebit'a on the Navajo Nation. I am the Zuni clan of Tachitni and born for the Tewa Bear Clan. I currently reside in Lenapehoking, and I'm here with the American Indian Community House. Thank you so much for joining us this evening. This series is hosted by the American Indian Community House to provide an intentional online space to collectively explore and discuss resources and information regarding Indigenous issues and conflicts that directly affect us today. Through shared concern and efforts, we will discuss action, solutions, and the many different ways we can contribute toward the movement and change making. Online in solidarity led by and for Indigenous folks, we will focus on providing a space that is accessible, respectful, and in unity. Check out H Instagram, Facebook, or sign up with the newsletter for the H website to keep up to date on the upcoming events. There is programming on Wellbriety support, elder storytelling, makers labs, at-home fitness classes, census events, as well as the series. Additionally, we started the Native Theater Thursdays, which has been going for about a month or two strong so far. Again, I'm so happy to have you all here. Our past SJS focused on Native-led movements happening in Mashpee, Shinnecock, Wet'suwet'en, and Southwestern tribal territories, as well as issues in Lakota territory, and now for our Southern relatives. Throughout these installments, we are continuously working on our collective understanding of how to garner intertribal solidarity, flesh out our definitions of self-determination, and share resources. Some updates for people attending this series. If you haven't already heard before, we are moving this event to every other week, so it's bi-monthly, in favor of spending more time building our SJS handbook. So today we will be sitting down with the 5 Southern tribes to talk about updates on the recent McGirt versus Oklahoma Supreme Court cases. We all now have heard the recent big win for our relatives down south, but what does it mean and how can we continue to show support for our relatives? We will have a panel and discussion with Robert Miller and Mary Holbetta to discuss the history leading up to the big win and what it means in relation to land and jurisdiction. So without further ado, I would like to introduce our panelists. If you could just quickly introduce yourself, where you're calling in from, and whatever you think is necessary for our audience to know. Robert, could you introduce yourself first?
Sure, I'm Bob Miller. I'm a citizen of the Eastern Shawnee tribe, which is also located in Oklahoma and is very interested in the implications of the McGirt decision. I'm a professor at Arizona State University, and I'm coming to you today from sunny Portland, Oregon, where I'm hiding out from the virus and the heat in Phoenix.
Awesome, awesome. And Mary.
Yeah, hi everyone. My name is Mary Holbetta. I'm a proud citizen of the Chickasaw Nation and a descendant of the Muskogee Creek and Seminole Nations of Oklahoma. Grew up here in a suburb just north of Oklahoma City, and for the last 7 years, well, rather the last decade, I've been on the East Coast. And this past May, I just graduated from Columbia Law School, and I'll be heading out west starting next year to work in Indian law and intellectual property.
Awesome. We're so lucky to have you both join us and hear what you all have to tell us about what's going on and what we can expect in the coming moments. As for the agenda, introductions, we've gone through that. We're going to quickly jump into a presentation, and we're just going to go ahead and follow along with a PowerPoint that was created by Bob Miller, and Yeah, so without further ado, we'll go ahead and jump into that for some history and some context. Give me a moment while I share my screen.
Well, I can start talking. In 30 minutes, we're going to try to cover a topic that we could spend hours discussing. And for some of you, maybe this Indian law aspect is a new idea. So the next slide, please. I start all these topics with a statement by General George Washington to Congress in 1783. And that's a lot to read. You can read it quickly. But what he's really saying is the United States should not fight wars with tribes, but they should just buy land from tribes. They should force Indian peoples back continually. And you can see what I've underlined. This letter is called the George Washington Savage is the Wolf letter. And look, he compared us to animals. And he said, and there's the underlined part, that the United States, Americans, God intended for Euro-Americans to have all the lands in North America and all the assets. And he says the gradual extension of our settlements will as certainly cause the savage as the wolf to retreat, both being beasts of prey, though they differ in shape. That's about as ugly language as I can imagine, comparing Indian peoples to animals to be driven away so that Americans could have the land. This policy is a lot about what happened in Oklahoma, what happened in the Indian Territory, what happened to Mary's tribe, what happened to my tribe. Next slide, please. If you don't know what the allotment era is, it began in 1887 with an act passed by Congress and part of George Washington's policy and his theory, and the policy that the United States followed for about 180 years was to get Indian lands as quickly as possible, as cheaply as possible, and as easily as possible. And so once there were reservations starting in the 1850s, the United States wanted to break even these reservations up and to get those lands into the hands of Americans, not in the hands of Indian nations and Indian people. So the idea came to allot reservations, break them into small pieces of 160 acres for heads of families, 80 acres for other adults, 40 acres for children. That was usually how reservations were broken up. And so tribes, as you can see from that slide, lost 90 million acres of land from 1887 to 1934. And that very next point, you can see that most of the land we had left was desert or semi-desert, so nearly worthless land. And my last bullet point there, gee, this is exactly what George Washington foretold, isn't it? And what treaties promised didn't matter. Next slide, please. The McGirt case, well, okay, U.S. Constitution. I didn't have that one printed down. Treaties are the supreme law of the land. But notice that second bullet point. Congress can unilaterally abrogate. That means to erase. Congress can get rid of treaties we've signed with foreign nations. And in 1903, the U.S. Supreme Court said that Congress can do the same thing to Indian treaties. So my tribe signed about 11 treaties with the United States. I can't imagine how many the Creek Nation did. I've heard the Cherokee Nation signed over 15 treaties with the United States. Congress can reverse those treaties almost any time it wants to. Next slide, please. My main point on this slide is that treaties are contracts between nations. There are 375 treaties that the U.S. signed that the Senate ratified. There are hundreds of more treaties that were never ratified by the Senate, but they become constitutionally valid and binding on the U.S. once the Senate enacts them. The Creek, as we're going to see, entered numerous treaties with the United States and had a contract with the United States about the existence of their rights as a nation, as Indian peoples, and with a reservation and land rights. Next slide, please. So this is the treaty the Creek signed in 1832. Many of you have heard of the removal era, the Trail of Tears. My own tribe was located in southern Ohio. We signed an 1831 treaty to remove from Ohio and move to the north, to the Indian Territory. The Creek signed a similar treaty in 1832. The Creeks were paid for their lands in Alabama and Georgia. They were given gifts. They were given payments. They were induced to move by promises of teachers, blacksmiths, and the nation demanded that they receive their lands in what's called fee simple absolute. For those of you who are not lawyers, fee simple absolute is the highest form of private property ownership that Anglo-American English United States law recognizes. And instead of taking this land in some sort of trust status, the way we use those words today, the Creek Nation demanded to have the fee simple title to their lands, and the U.S. agreed to that. Notice the last bullet point there. This 1832 treaty, while the Creeks were willing to remove west of the Mississippi, they demanded and were promised a permanent home, never again to be under state or territorial law. Next slide, please. Once the Creeks arrived in Oklahoma, the Indian Territory, they signed their 1833 treaty that designated the 6.5 million acres of land in that Indian Territory that were the Creek Nation Reservation. Again, none of their lands were ever supposed to be inside any sort of state or territory. Notice how often the Creek argued about this and insisted on this promise. Other tribes did the same thing. Look how the Creeks were going to have the unrestricted right of self-government and full jurisdiction over their citizens and their properties. Next slide, please. The Civil War, of course, came along, and the same thing that happened to the Creeks happened to my tribe. We'll see a map in a little bit. My tribe, the Eastern Shawnee, is located in northeastern Oklahoma, east of Cherokee and northeast of Creek, etc. The Union withdrew from Oklahoma. The Indian agents of the Bureau of Indian Affairs even left Oklahoma, and the tribes were stranded and faced with the troops from the South. And so, not surprisingly, most of the tribes in Oklahoma signed treaties with the Confederacy in 1861. And after the war, you see the second bullet point there, the United States, the reunited United States, called a conference at Fort Smith, Arkansas, and took us to task. And you notice I have GW there, George Washington. Oh, another opportunity for the United States to take more lands from Indian nations. And that's exactly what the United States did. They chastised us for signing treaties with the tribes while we were pleading back, hey, you left, your troops left, the federal agents left, and we had to deal with the South, and that's why we signed these treaties. The United States didn't care. And so you can see the treaties of 1866 that the 5 civilized tribes signed with the United States made them give up, cede, sell half their territory to the United States at what looks like a pretty cheap price, 30 cents an acre. But don't forget what this 1866 treaty said. The remainder of the Creek Reservation, 3+ million acres, was to be, again, forever set apart as their home. And the treaty even used the phrase for the first time, a reservation, and called the Creeks lands a reservation. Next slide, please. This is a pretty good map. Don't know where I got it. Borrowed it from the okay, it's borrowed, but you can see the 5 civilized tribes were the large tribes that received, that bargained for enormous areas of land. But the 1866 treaty made them cede all that darker gray part to the west. And the territories that those tribes retained as reservations are outlined there. Now remember, this case is only about the Creek Nation. You can see its outline right there. Every newspaper heading that you read about this case is, oh, half the state of Oklahoma is now Indian country. Well, that's not correct. The McGirt case only decided issues for the Creek Nation. Next slide, please. I guess I've never, so here's a better map, or it shows the other tribes that came to Oklahoma or were given lands. And I want to point out the most important tribe in the United States. Notice at the top of the page, there's the Eastern Shawnee. As you can probably guess, that's my tribe. So that's where we are still located today. Now, I've not really said, who is Mr. McGirt? What was the case about? Well, Mr. McGirt was a criminal, a heinous criminal, who was sentenced to 1,000 years in prison plus life. I guess the 1,000 years wasn't enough. In Oklahoma prison, convicted in Oklahoma state court. He finally began what are called post-conviction proceedings and was arguing Oklahoma, the state, never had criminal jurisdiction over me because I'm a Seminole Indian and my crime was committed inside the Creek Reservation. So he has been litigating this question for quite a few years. He lost at all levels of the state court in Oklahoma, and then the United States Supreme Court took certiorari of his appeal to hear this question, whether the Creek Nation reservation still existed. And the term is Indian country. 18 U.S.C. 1151 defines what Indian country is. And so the Supreme Court was faced with the question, does those boundaries of the Creek Nation reservation, do they still exist? And if that's the case, then Mr. McGirt was illegally, improperly convicted and prosecuted by the state of Oklahoma. Next slide, please. Here, Mary's going to address this, and then I'll come back to discuss what McGirt did.
Great, thanks, Professor Miller. So there are a couple of cases leading up to McGirt that established the existing doctrine for when the U.S. Supreme Court is reviewing a matter in which Congress's intent to establish or diminish a reservation is in question. So the first and one of the more significant cases involving this type of question is Solemn V Bartlett, and through that case, it established three principles to measure Congress's intent to diminish a reservation. So the test involves three different elements. The first is that only Congress has the power to diminish reservation boundaries. So the first question that the court must evaluate is what is the clear congressional intent? And you can glean Congress's intent by analyzing the specific language in the statute. So at this point in time, though, it wasn't really clear, were there magic words that we needed to look for to actually say, well, here's clear congressional intent, or in the earlier version of McGirt in the Murphy case, the state's approach was to kind of bring this hodgepodge of 10 different statutes and make the argument that together we can see Congress's intent to diminish or disestablish the Muskogee Creek Reservation. So at this point in Solemn, though, we didn't exactly know what clear congressional intent is, but as we'll see later, McGirt kind of answered that very clearly and put a particular emphasis on this first element of the test. The second and third elements are looking to contemporaneous events that would indicate understanding that the reservation might have diminished over time, or similarly that due to the current demographics of the reservation boundaries and the history of the reservation, maybe there's an argument to be made in support of diminishment or disestablishment. But we do also know at this point that the Supreme Court has made clear that allotment in and of itself does not mean that a reservation has been diminished or disestablished. So following Solemn, I can go ahead and hit the next slide, please. Following Solemn, just a quick note, we had a case in 2016, pretty recently, in Nebraska v. Parker, in which they applied the Solemn test. So now you have the Supreme Court looking at the Solemn test again, and similarly, they applied it to look to whether Congress had clear and express intent to diminish the reservation by looking to the text of the statute. And then again, they sort of looked at, in that case, the court may evaluate the circumstances surrounding the sale of land on the reservation and whether there's enough sort of extraneous evidence that demonstrates that the act might have, that a congressional act might have diminished the reservation. And then it did sort of de-emphasize that third element. To a lesser extent, the court may examine the demographic history of the land. And also, just another side note, in both Solemn and Nebraska v. Parker, the court affirmed that the tribe's treaty boundaries had not been diminished. So the way in which this test had been applied already sort of favored tribes, but still there was a lot of unclarity, specifically at the time that McGirt was granted certiorari, how this would apply for purposes of the Major Crimes Act and for tribes that had been removed to Oklahoma. Because as Professor Miller had indicated, there's a very complicated and long history for specifically the 5 tribes that had been removed from the southeastern part of the U.S. to Oklahoma. And now sort of exist in a space in which the localities and municipalities inherently engage with tribal citizens and tribal governments on a day-to-day basis. So the realities here for the 5 tribes in Oklahoma are not so much like the tribes with contiguous reservation boundaries that you might see in the Northern Plains and North Dakota or South Dakota, where it's a very clear distinction between a tribal reservation and in state land or fee land. So the importance of the McGirt case is that it would potentially offer clarity for the Muskogee Creek Nation, at least, in terms of the existence of its treaty boundaries. And so, as indicated here on the slide, the U.S. Supreme Court went through the Solemn test again, but made gave strong credence to the first element of the test, which goes back to looking at whether Congress has made a clear intent to diminish or disestablish a reservation. And so in the oral arguments and in the briefs, Oklahoma, the state of Oklahoma had claimed that the allotment laws showed that there was no Muskogee Creek Nation reservation in the first place, which another thing to note is a related case that would have answered the same questions for the Muskogee Creek Nation was the Murphy case, Murphy v. Carpenter. But the Supreme Court in the previous term had sort of punted that and decided to not issue a ruling on that. But it asked the exact same legal questions in terms of whether the Muskogee Creek Nation reservation boundaries were still intact for purposes of prosecutorial authority under the Major Crimes Act. So a lot of the arguments were very similar. The counsel for the tribe and Mr. Murphy remained the same, but the state of Oklahoma made a different argument in that first, in the Murphy case. There was what I had mentioned before was they took all of the allotment statutes and the Oklahoma Enabling Act and a lot of other congressional measures to try to make the argument that if you somehow read these together, you can see that there's sufficient congressional intent that Congress didn't want the Muskogee Creek Reservation to exist today. But again, we'll never really know how much the court, gave merit to that argument because they didn't issue an opinion in that case. But for when the Oklahoma State counsel for the Oklahoma State came back to make arguments in McGirt, they changed it a little bit. Instead of saying you can kind of find congressional intent by looking at these statutes, they actually said that Muskogee Creek Nation didn't actually have a reservation in the first place. And so that, that's a bolder argument to make, but counsel for Mr. McGirt and the Muskogee Creek Nation continued to make a similar argument to what they made in Murphy, and saying that Congress never explicitly diminished or disestablished the reservation for purposes of criminal prosecution under the Major Crimes Act, which was at issue in this case. So they really, both the parties and Justice Gorsuch, in his opinion, focused on that first element. And interestingly, instead of going into detail about the second and third elements, sort of as the court did in Nebraska v. Parker and Solemn, Gorsuch made an interesting claim, and I think it's on the next slide, sort of discussing how once we've already answered the first element, there's no need, as you can see on the second bullet, there's no need to consult extra textual sources when the meaning of a statute's terms are clear. So essentially, it's almost as if instead of the Solemn test working element 1, 2, and 3, it's now, if you have 1, then maybe there's not a need to consider 2 or 3 at all. Maybe you don't even get to those extra circumstances, or even more importantly, the third element, which was the reservation's history and demographics, which I think is important because it, one, makes clear that Congress Congress alone has the authority to diminish or disestablish a reservation. And if it wants to do that, it has to do that by statute, and it must say so very clearly, because otherwise the court is not going to read in congressional intent from extraneous factors such as, all of the non-Muskogee Creek citizens who live within the Muskogee Creek Nation boundaries, or who live in that part of Tulsa that are within the Muskogee Creek Nation's treaty territory. That the fear-mongering narrative that the state's attorneys pushed in Murphy and in McGirt aren't really effective if you have very clear congressional language. And so I think it's on the next slide where we actually see, so this is more, I believe, from Gorsuch's majority opinion in McGirt, just essentially saying that he's applying the written law. He's taking a very straightforward textualist approach. You look at the statute and you see that Congress didn't intend for the Muskogee Creek Nation treaty boundaries to be disestablished or diminished today. And barring that intent, you can't read it from these extra sources. And specifically, he's looking at other areas of statutory interpretation that do a very simple application of reading the text in front of you, taking it as sort of its plain meaning, and if it's not there, then not engaging in sort of a speculative reading of the language. So that's sort of him rejecting that approach of having a statute and then sort of also bringing in all of these other narratives that don't really tell us exactly, what Congress might have thought when they were enacting these laws. And so if we go to the next slide, I think this indicates—
Could I join in here, please?
Sure, go ahead.
Could we go back about 4 slides? Let me make a couple of comments too. Skip that one, go forward. So in McGirt, exactly like Mary's discussing, the court alleged that it borrowed the Solemn test, or that it followed the Solemn test. The dissent objected vigorously, and in fact, the dissenting opinion is longer than the majority opinion is. The dissent lays out what I call chaos. The sky is falling, what Mary was referring to. All these things that have occurred since Oklahoma became a state, and almost everyone assumed there was no reservation anymore. Now, I'm writing an article on this topic, and not 15 minutes ago was I typing up the Oklahoma Enabling Act, the statute that allowed Oklahoma to become a state. Congress makes every state do that. Congress lays out certain requirements before this territory can become a state. And Oklahoma disclaimed, gave up any rights over Indian lands and properties within its state. And so then Congress allowed them to become a state and to write a constitution. In the first Oklahoma Constitution, the state gave up, disclaimed any jurisdictional right over the lands of Indian nations. And then for 113 years has ignored that completely. So when we go back to the Solemn test, and then whether steps 1, 2, or 3 are to be used, McGirt is a ground-shaking earthquake of a case. I call it a bombshell, and I think it is the most significant Indian law case in 150 years or so. The ramifications that Mary and I will be talking about later, and the potential changes in Oklahoma, I think are pretty dramatic. And as far as, I just can't hardly think of other Indian law cases that had such an impact on a state and a society, and will involve all sorts of negotiations, maybe litigation, maybe legislation to change. But there is no question that the majority opinion written by Gorsuch relied only on step 1. They looked at this long chain of statutes that Oklahoma and the dissent argued were a disestablishment of the res, and the majority says no. The majority looked primarily at the 1901 Allotment Act. Again, that's why I had that slide on allotment, when the Creek Reservation was broken into little pieces of land to be given to individual Creek citizens. But as Mary pointed out on that slide, the Supreme Court has said numerous times that allotment does not change the borders of a reservation. It does not diminish it, make it smaller, or disestablishment disestablish it, which is a complete erasure. I want to mention just one piece of history, which is why the majority decided that Congress never disestablished this reservation. In 1893, Congress sent what's called the Dawes Commission, a Dawes Commission to go negotiate with the Creeks. And Congress told them to try for two things. Try to get the Creeks to sell us some land, and if not, try to get the Creeks to agree to allot their reservation. The commission reported back the next year in 1894 that the Creeks refused to sell any land at all. And so Congress said, okay, well, negotiate about allotment with them. That right there shows Congress did not think that it was buying or disestablishing the Creek Reservation. All it was doing was providing an allotment act that would provide an opening and privatize some of the lands within the reservation. So next slide, please, because Mary mentioned this, but I want to show you that here's where the dissent just about has a conniption fit about the fact that the majority opinion did not consider step 2 and 3 of Solemn. And that's a quote from the majority opinion. Look what he says. On the state's account, we've only done the first step. 2 more await. What does he say? This is mistaken. And as Mary said, when Congress's language is clear, we stop there interpreting a statute. There's a very interesting point, if you have followed this, folks, this argument about originalism, how we interpret statutes and constitutions. And those like Justice Scalia and Gorsuch, and to a lesser extent, Alito, Thomas, and Roberts, they argue you go back, if the statute was written 200 years ago, you have to decide what they originally thought the statute or the constitutional language meant. And so that's what they mean by originalism. So Gorsuch says, hey, I've read these statutes. They do not terminate or disestablish the Creek Nation Reservation. We had nothing else to do. Look what he says after that citation to a very recent case. That is the only step, and he puts quotes around the word step. I do not think he believes in this 3-step Solemn analytical process. And Mary read you the bottom one. Do not consult, and here's what an originalist would say. If the constitutional provision or the statute from Congress is clear, we don't read other material to try to make the clear language vague. The court uses the word ambiguous several times and makes this point. We do not look to other evidence to try to create ambiguity out of clear language. So the court stopped at step 1. And the court didn't even like calling it step 1, to tell you the truth. So I just wrote another sentence this morning. I wonder when the next lawyer will argue to the US Supreme Court about the 3-step Solemn test, because Gorsuch might throw his gavel at them. Next slide, please. And Mary mentioned this one too. Now, this is the message that the dissent and Oklahoma wanted to present. Chaos. The Chicken Little argument, the sky is falling. If you say that Creek Reservation all of a sudden is 3,250,000 acres, how can that be? And so Gorsuch mocks that idea. And I don't want to read all that to you. You can read it faster than me, but oh, how much easier to let the state proceed as it has always assumed it might. But just imagine, then Indian landowners lose their title by fraud or otherwise. And folks, that happened egregiously in Oklahoma. The courts and the attorneys were, some, of course, not everyone, but were involved in fraud. Wait till the movie comes out about the Osage and the murders of Osage people to try to get all the oil rights into the hands of a non-Indian. Wait till you see that movie Martin Scorsese's making. But look at that. Then, oh, gee, now a reservation that was once beyond doubt becomes questionable and then even far-fetched. That's what Oklahoma and the majority want you to believe. It's far-fetched to think there's still a Creek Reservation. Of course, it says sprinkle in a few predictions here, some contestable commentary there, and boy, the reservation's gone. Now, I underlined that bottom part. None of these moves would be permitted any other area of the law. And there is no reason to permit them here. And I love this last sentence. That would be the rule of the strong, not the rule of law. Elsewhere in the opinion, he uses that same idea, but references or changes a little bit. Something like that would be justifying the people engaged in illegal, or I think he said it this way, that would be supporting those who had acted illegally, wrongfully, and ignored those who were in the right. So this case is wonderful for an Indian law advocate and is going to have a big impact in the future. And I think that's, what time is it? And I get talking fast because what if we have 12 minutes if you guys are going to shut us off at 7 p.m. When are we going to be shut off? Do we have 2 more hours there?
Well, it's like pretty flexible. So I think as long as people are interested, I think like people will definitely have questions. So I think
Mary was going to talk about the consequences. And so maybe we should get into this chaos that has been predicted.
Right. Okay. So is that this last slide here?
Yeah, I mean, a few of the points that I had planned to cover are on this slide. So we have the McGirt opinion issued on July 9th, which for those of us here in Oklahoma who've been working on the aftermath of McGirt, that seems like a million years ago. But on July 9th, we have the McGirt opinion. And it seems like the week thereafter, it's a lot of celebration among Muskogee Creek citizens, and likewise among citizens and community members of the other 4 of the 5 tribes here in Oklahoma. And it's as Professor Miller indicated, it's a landmark decision, not only for reading the Solemn test and making sure that Congress does the work that it was authorized to do to assert its plenary power and to make clear if it's going to diminish or disestablish a reservation. It has to make it clear and that the court isn't going to make their job any easier, and they're not going to read into it. So that's just from a practitioner's perspective. That's wonderful that we have something like that on the books, because I think just speaking in my personal capacity, many of the U.S. Supreme Court cases in which tribal interests are involved oftentimes end up getting ruled on inconsistently with legal precedent, and sometimes more on party lines or politics, or the compelling narrative of what's going to happen to the non-natives. What exactly would this mean to rule for a tribe, but what does that mean for non-Indians? So for once, I think the McGirt opinion does represent the court doing the job that it was tasked with, and applying the law reasonably and objectively. And in this case, it came out for the tribe, and I think that was the right way to go about it. And so we had that week of celebration, just taking it in and trying to figure out exactly what does this McGirt opinion mean. One of the main questions surrounding that time of elation was, well, again, this opinion only impacts the Muskogee Creek Nation. There is a strong argument that can be made that it also similarly would apply to the other 4 of the 5 tribes here in Oklahoma that were removed from southeastern part of the U.S., given the similar statutory histories that led to the establishment of their reservation territories. However, in reality, and especially just sort of speaking as someone who has grown up here in Oklahoma, who is here and is very aware of the sometimes hostile dynamic between tribes and localities and the state government and the federal government and all these other different sovereigns, a real question was, maybe McGirt, what if McGirt only decided this for the Muskogee Creek Nation? And does that mean that the Seminole Nation, the Choctaw Nation, the Cherokee Nation, and the Chickasaw Nation all have to have their own respective McGirts and have to have the U.S. Supreme Court decide the same question for those 4 tribes? And I think it's plain that that approach would mean several more years, if not decades, of litigation leading up to the U.S. Supreme Court. And it's a very piecemeal approach to getting this, to implementing McGirt, but also applying it to tribes that were implicated in this case as well. So interestingly, though, while we were all kind of ruminating on that question, a week after the McGirt opinion was issued, the Oklahoma Attorney General Hunter issued a press release announcing an agreement in principle between his office and the leaders of the 5 tribes. And the agreement contained a set of recommendations that were to be presented to Congress for enactment that would delegate federal prosecutorial authority to the state. So essentially, McGirt allowed prosecutorial authority between for the federal government, but through this agreement, the state would also have that authority. So not so surprisingly, shortly thereafter, the leaders of the 5 tribes issued a joint statement endorsing the agreement. Each of the 5 tribal leaders contributed a short quote supporting collaboration with the state and federal government to promote justice and safety throughout their respective tribal boundaries. However, the next day, July 17th, the Muskogee Creek Nation principal chief issues a letter to his citizens clarifying that the nation does not support the proposed agreement or the need for federal legislation. And that same day, the Seminole Nation principal chief announced that his nation was not even involved in the discussions leading up to the agreement and does not support it. And that was also the day that Cherokee Nation's Chief Hoskin issued a video with the Cherokee Nation Attorney General discussing the agreement in principle and making the case for pursuing an approach to have federal legislation that would clarify how McGirt would actually work out in practice in such a way that would avoid the piecemeal litigation route that I had discussed earlier. But a few days later, we have the Chickasaw, the Cherokee, and the Choctaw issue a short announcement on just welcoming dialogue on the proposed approach to craft some sort of federal legislation that would clarify, how the 3 sovereigns, the state and federal government, and the tribes retain prosecutorial jurisdiction over major crimes, but also maybe get into the extent to which the state might have jurisdiction in the civil realm. But that's all sort of up for discussion right now. And in terms of where we are now, the Muskogee Creek Nation chief issued an executive order just a few days ago establishing a protection, it's called the Muskogee Reservation Protection Commission, that will provide internal recommendations to the tribe about promoting safety for all residents living within the Muskogee Creek Treaty boundaries, along with engaging with the federal, tribe, and state partners. But we also have, and I think it is on the slide, the Hobart case. On July 30th, the 7th Circuit Court of Appeals actually applied the McGirt holding, and they found in favor of the Oneida Nation in its dispute with the village of Hobart. And the court held that the tribe's treaty boundaries were never diminished or disestablished, and that accordingly, the village of Hobart could not enforce its demand that the tribe obtain that the tribe obtain a municipal permit in order to hold its annual festival on land that was partially owned by the village. So we're already seeing the ramifications that McGirt is having in the lower courts in places outside of Oklahoma. And I think I think we'll probably continue to see other lower courts apply McGirt. But I think what's very important, and something that I want to really kind of drive home to the listeners today, is that we also have to keep in mind what the reality is here in Oklahoma. And that reality, unfortunately, is that on a daily basis, tribal advocates deal with terminationists. And it is, there's a way to view that agreement in principle that was proposed in a way that puts the leaders in a light that shows that they were actually perhaps trying to get ahead of the game and get ahead of the terminationist legislation that maybe, you know, the oil lobby or other adverse interests might try to put forth in Congress to go ahead and terminate the lanes of the 5 tribes. Because at the end of the day, Congress's plenary power is very broad, and that is always a possibility despite McGirt. And so as an act of sovereignty, as an act of protecting the sovereignty of a tribal nation, I think it's our tribal leaders' duties to try to prevent that from happening and encroaching on our sovereignty through Congress. And one of the ways to do that is to kind of beat the other parties to the punch and go ahead and present them with an agreement that other similarly situated tribes have already consented to, along with input from the state attorney general to say, this is what we agree with in terms of implementing a roadmap on the path forward. And if you're able to enact this, Congress, then we can go ahead and move forward. And that's also more of a blanket approach that avoids individual compacting that we might see with other issues. And also, at the end of the day, we're dealing with a delegation of federal authority, and the state and the tribes don't have the authority. Only Congress has the authority to delegate federal authority to the state. So we just have to, I think, bear in mind the reality that we're dealing with, and take it to heart that while McGirt gives cause for celebration, it also is a signal to remain vigilant and to do everything that we can to protect our tribal interests as it relates to protecting our sovereignty.
I agree with Mary about remaining vigilant. Obviously, people are already worried, and from day one, July the 9th, worried about Oklahoma senator or congressperson maybe sneaking in what people call a midnight rider, attaching some sort of quick little bill or little language to some like defense bill or the CARES Act or something that just absolutely is going to go through Congress. So we have to look out for ourselves. I'd like to make 3 other comments, or 4, I suppose. First off, the reason I call this case a bombshell is because how Justice Gorsuch has apparently changed the decisions of Indian law in the United States Supreme Court. From 1986 to 2015, tribes and the Indian litigants in cases lost 80% of their cases in front of the US Supreme Court. 80% we lost. Since Gorsuch has come on the court in April of 2017, so just a little over 3 years now, I believe there have been 6 Indian law cases in front of the Supreme Court, and we've won at least 4 of them in which Gorsuch's vote and participation was important. And now he writes the majority opinion in McGirt. I don't think we've said this yet. It may have been on a slide, but we only won McGirt by 1 vote. Where's my hand? 5-4. So if something, the court could change, we will only see in the future if Solemn has been changed, or if Gorsuch and Solemn, the cases can live together and be coordinated and be used in the future. Secondly, I'd like to comment on what Mary said, though. I think I disagree a little bit. Even the 5 civilized tribes don't have the same identical history, to my knowledge. Their treaty languages might be different. Statutes that Congress passed about them might be different than what was looked at in the Creek Nation. So I don't think other tribes can just piggyback off of the facts in the Creek Nation case, McGirt. My own tribe, we'll have to read our treaties. We'll have to read. In fact, Congress did not pass an allotment statute for my tribe like it did for the Creeks. The local area agent, BIA agent, and the Commissioner of Indian Affairs in DC decided my tribe's reservation would be allotted. So we have no congressional history about what allotment even meant on us. So, you know, I really wonder if our 14,000 acre reservation boundary still exists to this day. But these cases can rise and fall on specific facts or specific congressional language that's pertinent only to that tribe, perhaps. So I do think there will be more litigation in the future. What Mary mentioned, if there could be some compromise with the state and some all-encompassing agreement that settles a lot of these issues, that would be, could be, to the advantage of all Indian nations in Oklahoma. But what just scared me about that agreement in principle that Mary mentioned, so you say that was a week later? I thought it was like the next day, but this was a week later. The Attorney General had this 2-page agreement that obviously the parties have been working on for months. I have a feeling the tribal leaders thought we were going to lose McGirt, and now we win it. Now, I've read that document only once, so I haven't studied it closely, but it looks like it is far worse than if we had lost McGirt. The 5 tribes that were just what had been agreed on in principle was worse than losing McGirt and would have hurt perhaps all the tribes in Oklahoma. So we'll see where that stands. 2 tribes, as Mary said, have changed their mind about it, but you tell me, and that's news to me, but the leaders of 3 tribes just a few days ago said they still want to pursue an agreement. I'm not against that. Obviously, it's tribal sovereignty for these tribal leaders to make these decisions. It's not for me or Mary to tell tribal leaders what to do for their nation, but we certainly have the right to comment. And as citizens of some of these tribes, we have the right to do some screaming. But what I would say is absolutely, if you're going to negotiate and agree to something, get something from it. Don't just give everything up. And that's what that first agreement looked like to me. Let me see. I mentioned I thought there was one more point I wanted to make, but it looks like that's about all I have to say. There are articles in the New York Times today about criminal issues that are already popping up in the Creek Nation. Can the U.S. Attorney's Office handle all these prosecutions? Can the Muskogee Creek Nation court system and government handle all the issues that are going to arise? So this is, like I said, a bombshell. And this is going to present challenges for all the governments in Oklahoma. And so maybe ultimately some kind of negotiation and settlement is the route to go. But let's not just give up the win of McGirt tomorrow. I think that's about all I have to say.
Thank you both so much. That was very, very thorough. For the people tuning in through Zoom and the people that are tuning in through Facebook, we do have a short Q&A period. So if you have any questions for Mary or Bob, definitely type those questions into the chat and send them to us, and we'll read your question and have an answer for you. Yeah, thank you so much for everything. The coverage of everything was, like I said, very, very, very thorough. It answered a lot of the questions that I had. Yeah, I guess, let me see. Do you have any like sources, like news sources where people can keep up to date, especially relatives that are maybe not as fluent in law jargon? And that can be a question for either of you.
Well, I gave a 1-hour webinar on this case for the Oregon Historical Society on July 16, and that was for a non-legal audience. There were about 47 Oregon attorneys on the call, I noticed. But I think, according to the Oregon Historical Society, there were a couple thousand people that touched on it, and it's on Facebook too. So a person could look for that, and I spend 1 hour going into greater depth than we were able to today, and hopefully not at a lawyerly geek level.
Yeah, I would just add 2 additional resources. The first, just being the Muskogee Creek Nation's Facebook page. The principal chief of the Muskogee Creek Nation has been doing occasional updates via video on their Facebook page. So if you want to hear it directly, updates directly from Muskogee Creek Nation principal chief, then I would look there. Similarly, the chief of the Cherokee Nation has provided updates to people on Facebook about the agreement in principle and developments following that. So I would just look at those tribes on Facebook. It seems like there's been an outpouring of interest from citizens of these 5 tribes wanting to know, what's happening with the agreement and what are the next steps, so on and so forth. And so you can hear all of the various perspectives from each tribe's Facebook page. And then a second source would be Turtle Talk, which is a blog and does tend to lean towards the legalese. But if you go to the blog and just search for McGirt, they do a great job of hosting all of the news articles and op-eds that the chiefs have written in, like, the New York Times, the Washington Post, and so on and so forth. So if you're interested in following all the various commentaries on the case that are in major publications, I would do a quick search on Turtle Talk.
Well, I will get in trouble if I don't mention this. My own school, I teach at Arizona State University, and we have the Indian Legal Program. And on July 23, we did a 90-minute webinar on the McGirt case, and I was just one of 5 panelists. We had our Professor Larry Roberts, who's the ex-acting Assistant Secretary for Indian Affairs. We had Professor and ex-Dean Stacy Leeds, who's a citizen of the Cherokee Nation and was on their Supreme Court. She's one of the commentators. And we have John Adev Chadhuri, who is an attorney in DC. He's Creek. He's the ambassador for the Muskogee Creek Nation. He was on the call. And we had Derek Beetso, who's the general counsel for the National Congress of American Indians, and then myself. So we had 5 people. That's available online. If you search for ASU Indian Legal Program, you can find that 90-minute webinar. And there were about 1,200 people on that webinar on July 23. So that would be very worthy to hear what Professor Leeds, Professor Roberts, and Ambassador Chadhuri have to say.
Cool, awesome. Definitely follow up with that, with those resources, and I'll be sure to keep those on hand as well. And if you want some of those resources, feel free to reach out to me by responding to my emails, or reaching out to me or H on any of our social medias. We do have a question from Facebook, and this is directed towards you, Bob. It says, specifics on how agreement in principle is worse than if lost the case.
The court, that agreement, I read it once, 2 pages. It not only gave back everything that McGirt won, if I can't remember the exact wording, I read it 3 weeks ago, but it would have returned, I think, criminal jurisdiction to the state. And it even would have put into federal law civil jurisdiction issues from a case that most Indian country does not like, United States versus Montana in 1981. And it would have codified, turned into federal law, what had been just language from a US Supreme Court case. So when I say that that agreement in principle was even worse than if we had lost McGirt, that's what I'm primarily referring to. And that would have impacted all the tribes in Oklahoma, the criminal aspect and the civil aspect of the Montana case.
Right. Sweet. Well, we're pretty much close to our proposed ending time. I guess my last question, are there any other lingering thoughts or things that either of you would like to mention in regards to this topic and establishing sovereignty as Indigenous people?
Well, for me, this is all about tribal sovereignty. and all about governance of our lands, our peoples, our issues. So that's why I continue to say this is a bombshell of a case. And even as I said earlier, if tribal governments and tribal leaders decide to negotiate and sign some agreement, even if that agreement in principle that I don't like, if that had gone ahead, that also is sovereignty. That's governance. And it's up for those elected leaders that the people of their nations elected, made their leaders to make these kind of political diplomatic decisions. So I may not like a particular decision, but it is sovereignty to make those decisions. And so I am pro that, and I'm so excited about McGirt. What Mary said, I woke up on the 9th of July, and we had won that case, and I've been working on that case every minute since then. So like she said, this has become all-consuming. It's that big of a case.
Yeah, and I echo that sentiment as well, and would just add that these are very complex issues. And despite where each tribal leader has come out on the agreement in principle or the need for federal legislation, what every tribal leader of the 5 tribes has made clear is that they will not concede any bit of their sovereignty, and that they refuse to allow this matter to progress without a seat at the table. So something that is a point of consensus is that the leaders of the 5 tribes are willing to are making sure that they have a seat at the table moving forward, and that their voices are heard.
Awesome. We actually do have one question before we do our little sign off.
Just before you ask the question, if people have not heard this joke, the old saying is, if you're not at the table, you are on the menu. So we do not want to be on the menu. What Mary just said, I 100% agree with. We've got to be at the table, negotiating, exercising our governmental powers. Sovereignty.
All right, Lisbeth, see, we're trying to unmute you. There you go. Wait 1 second. You're still on mute.
Okay,
Okay, we can hear you now.
thanks. Lisbeth Natasha Luis Gonzalez Nachapayo Wonk, Taino Nachapayo, Gonzalez Nachashaya Wonk, Taino Nachapayo Wonk, the Bronx Natap. Greetings. It is a real privilege to be able to listen to this presentation today. I am so very, very happy to have had the opportunity to listen to your analysis. My concern is very simple, which is how do we broadcast today's presentation? I would like to share it, for example, with other members of the New York State New York Federal, State, Tribal Courts, and Indian Justice. No, let me start again. New York Federal, State, Tribal Courts, and Indian Nations Justice Forum, which exists in New York State as a liaison between the state and federal courts and the nations within New York State. This is really important, and your explanation is very understandable. And I think that the more people who are able to, the more people become aware of the decision and the importance of the way that the law was deconstructed by the Supreme Court is really critical. You know, for those of us who do legal analysis and who have to do statutory construction, this is incredibly important. I don't feel comfortable with commenting anymore because of my job, but I really, really, really am thrilled with today. So thank you so much. And to the Community House, thank you as always for making this possible. I saw that it's available on YouTube. So does that mean that we can share the link? Can you break it down like in simple terms for me?
Oh yeah, totally. So we are currently broadcasting live on Facebook on the American Indian Community House page. And tomorrow we will have it up on YouTube, and it will also be on the American Indian Community House page on YouTube.
Okay. I am cutting and pasting the address because what I have found is that the chat box, as you know, disappears once the presentation is over. And if you don't copy it, it is gone. So that's another understanding that we actually have to let people know about, because you don't always know this. But thank you. Thank you so much. And I'm so proud of you, Mary, for being a Columbia Law graduate, even though I went to NYU Law. I'm so proud of you. Well, we're rivals. So to the professor, you may not know this, but it's like the Yankees and the Red Sox. It's like blood in the waters.
I
But
understand
You and
that.
I can at least disagree on the Yankees.
but what a great job you did, Mary. Really, thank you. I'm proud of you.
Thank you. I appreciate it.
Awesome. Well, we're pretty close to time right now. Tanis, could you update us on the upcoming H events for this week?
Sure. Hi, everybody. For everyone on Facebook, feel free to share that video. It'll be live and available, and it'll also be on YouTube, and we will post that. I will send that out. Tomorrow is nothing. It's Wednesday. I have to think these through. Thursday, we have Native Theater Thursday at 8 o'clock. We're doing a play called Antigone. It is a Native adaptation of the Greek tragedy Antigone by Beth Piatote, who is Nez Perce. And Friday at 7 p.m. we have Two-Spirit Indigiqueer Bingo back. Native Theater Thursday you can watch on Facebook Live only. For bingo, you have to participate via Zoom only. And Sunday at noon, we have our talking circle, which is also private on Zoom. And then on Tuesday, we have Fit Native class back at noon. And that is it. That's also, you can come on Zoom or you can watch it on Facebook Live too. So if you want to RSVP to anything, just send us a message or an email and we'll get you that info.
Sweet. Awesome. Well, thank you for everybody that was able to tune in. And again, thank you so much. Bob and Mary, y'all did an amazing job. And yeah, if anybody feels like saying thank you, feel free to unmute yourself at this time, and or you can write in the chat box. But that is all I have for you all today. So
Thank you very much for having me on. Thank you, Tatiana.
Awesome. All right.
Signing off here.
Okay.
Okay.
Bye, everybody.
Thank you. Thank you very much.
Bye-bye, Mary. Nice meeting you.
Likewise. Take care.